Ladies and gentlemen, welcome to Freedom Day. That was, in the background, Bing Crosby singing A Song of Freedom from Holiday Inn, and I am Jeffrey Rosen singing A Song of Freedom from the National Constitution Center. I'm so excited to welcome you to this superb institution. The National Constitution Center is a very special place. It is the only institution in America, chartered by Congress, to disseminate information about the US Constitution on a nonpartisan basis. And that means that in these polarized times, we are one of the few people that brings together Americans of all perspectives, liberals, conservatives, and libertarians, to debate not political issues, but constitutional issues, so that the people can make up their own minds about what the Constitution means. Our purpose is to learn about, debate, and celebrate the greatest vision of human freedom ever achieved, the US Constitution. And we do that in three ways here at the National Constitution Center. We are the Museum of We the People in this beautiful building on Independence Mall, across from Independence Hall. We are America's Town Hall, and we've opened a series of national traveling debates co-sponsored by the Federalist Society and the American Constitution Society to debate the Constitution, and we are a national headquarters for constitutional education. Our motto, visit, learn, debate. Now, we host these conversations across a variety of media platforms, here at the center, around the country, with our great We the People podcasts, on video and on the web. But in some ways, the apotheosis of these constitutional conversations is the extraordinary day that you are about to experience. You are an amazing group of thought leaders from all sides of the constitutional spectrum, and you are about to hear the leaders of the top institutions in America, the top think tanks, including the American Enterprise Institute, the Cato Institute, the Aspen Institute, the American Civil Liberties Union, and the Center for American Progress, all discuss and debate what the left and the right can agree about and disagree about the future of freedom. And our goal during our conversations today is not necessarily to agree, it is to have a constitutional conversation, because it's only in the process of respectfully evaluating the best arguments on all sides of the constitutional debates at the center of American lives that people can make up their own minds. And that's why I am so thrilled to welcome you to these proceedings. It's now my great pleasure to introduce the visionary who made Freedom Day possible. Every great event has an animating spirit, and ours is the great Freda Levy. Freda, you came to me about a year ago and said that you thought it was important to inspire people around the country to talk about freedom. I loved your energy, your vision. You are a dynamo. You've made this happen. Tell this wonderful group what you are hoping to achieve with Freedom Day.
Okay, thanks, Jeff. Well, first, I actually want to start by extending my heartfelt thanks to Jeff and Leslie. As Jeff said, from the moment I proposed Freedom Day, he and Leslie Albanese saw the potential, and they've been energetic supporters. And I would praise Jeff even more, except he only gave me 3 minutes to speak. So why Freedom Day? I mean, after all, doesn't American culture extol freedom? And as Jeff mentioned, our very Constitution sets out the freedoms that impact our lives daily. I mean, everything from, think about it, people walk around this country dressed in ways that, you know, you may think is bizarre, like purple hair, tattooed, or on the other end of the spectrum, you have guys walking around with a yarmulke, women with chadors, and yet there is a part of us that sometimes reacts negatively when we see someone who's dressed in a way we find offensive. One of our goals, just a small goal of Freedom Day, is that when you see someone dressed in a way you may not like, you take a breath and you go, oh my God, I'm so thrilled I live in a country where people can live their lives as they please. And that's just one of the many freedoms we want to help Americans to realize, appreciate, and better protect. about this country. So why are you here? As Jeff mentioned, you are all thought leaders, yes, or else you wouldn't have been invited. And we are hoping that as you listen to the talks, you're thinking, what can I do? What can my organization do next year on or around Freedom Day to help Americans become more aware of these precious freedoms so that we can protect them? And we at the Constitution Center, hope you don't mind, I'm not going to ask for salary, but yeah, okay. We at the Constitution Center, starting right tomorrow morning, we're going to start planning a mega festival. It's going to be across the street on Independence Mall. It's going to be sort of the epicenter of Freedom Day. But we're also going to work with civic organizations across the spectrum and encourage them to have events in their cities, everything from the Chamber of Commerce, Rotary clubs, Boy Scouts. We're hoping that all of you will be holding events at your organization, be it a debate or just a celebration. We are going to get curriculum out to the public schools. We're going to engage businesses and the media, and we're going to raise money so that we can run ads so that the country is aware of this celebration. And some of you may be thinking, you know, this is sounding a lot like Earth Day. And you're right. Earth Day is our inspiration. And others of you may be thinking, but isn't this sort of like Independence Day, 4th of July? It isn't, because Independence Day is about our independence, gaining our independence from Britain. This is a day meant to recognize the freedoms that are enshrined in our Bill of Rights. And so with that, let's talk, it doesn't work as good as this. Let's talk about freedom.
Beautiful, bravo. That lady is a dynamo, a visionary, and a lover of liberty, and I'm so grateful that you've made all this possible. I mentioned the National Constitution Center's very special status as a nonpartisan institution, and we've been extremely fortunate in our leadership. Our most recent board chairs have included President George H.W. Bush, President Bill Clinton, and most recently, Governor Jeb Bush. And Governor Bush agreed to serve as chair of the National Constitution Center because his father, President George H.W. Bush, told him that service to the National Constitution Center was his most meaningful post-presidential service. We were honored to have Governor Bush's leadership, and I'm thrilled to share with you a video message that Governor Bush has offered to celebrate Freedom Day. Please welcome the former chair of the National Constitution Center, Governor Jeb Bush.
It was an honor to be the chairman of the National Constitution Center. It made me fall in love with the Constitution all over again. When I talk to young people, I always encourage them to really take the time to learn about the origins of the freedoms we enjoy in this great country today. I applaud the National Constitution Center's celebration of Freedom Day. It's a great idea whose time has come. We must restore a love of our country and its heritage and its traditions, and expanding that love in a way that gives people confidence that they can rise up, that they can live the American dream. The NCC plays an important role in that, and I'm glad I got to be a part of it.
Thank you so much. Some very brief housekeeping. Please, if you're watching us on live stream or on C-SPAN, please follow us on Twitter at Constitution Center, and you can tweet in your questions at the hashtag NCC Town Hall. We'll also be collecting note cards throughout the day to ask questions of the panelists, as well as handing out cards asking the audience to talk about what they conceive of as the central meaning of freedom, which we will read out during the extremely entertaining cocktail hour, which will include a stand-up comedy routine by Grover Norquist. It is now my great pleasure to introduce our first panel. This is co-hosted by the Aspen Institute. I have a special affection for that spectacular institution. The Aspen Institute gave me my start in moderating seminars about the Constitution many years ago, Gary, and Laura Lauder, and I see Laura just walking down with her usual perfect timing, invited me many years ago to moderate these conversations, and it was that experience, moderating for Laura. Here you can get a kiss if you like, but okay, here we go. Welcome. Laura had the great idea that bringing people around a table to talk about the Constitution could lead those of different perspectives to some kind of enlightenment. And it was among the most satisfying work I'd ever done as a teacher, and it was that experience that made me so excited to lead the National Constitution Center and try to make this a national model for that kind of civilized conversation. I should say we just had an incredible seminar for teens on Saturday, co-hosted with Aspen, and these young people drafted constitutional amendments in record time and had the most engaged, exciting contributions you could possibly imagine. So one of the many great leaders at the Aspen Institute is the moderator of our next panel, Meryl Chertoff. Meryl is the head of the Justice and Society program at Aspen. She teaches law at Georgetown. She was previously director of the Sandra Day O'Connor Project on the State of the Judiciary at Georgetown Law, and she is a masterful moderator on what has to be one of the hottest constitutional topics in America today, and that is the future of religious liberty. We have an extraordinary group that she will introduce. Please join me in welcoming Meryl Chertoff, Kristina Arriaga, and Greg Lipper, as well as Mark Gerson.
The First Amendment to the United States Constitution states that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. These words don't signal the end, but rather the beginning of a spirited debate about the proper relationship between religion and the American state. In the early years of the United States, some interpreted the First Amendment to mean that Congress couldn't establish an official religion, but cities and states could. By contrast, Thomas Jefferson described the First Amendment as erecting a wall of separation between church and state. In Everson against the Board of Education, the Supreme Court quoted Jefferson's words, urging that this wall must be high and impregnable. In Lemon against Kurtzman, however, the court recognized that some relationship between government and religious organizations is inevitable, adding that the line of separation, far from being a wall, is a blurred, indistinct, and variable barrier depending on all the circumstances of a particular relationship. The first president, George Washington, articulated an additional approach in his famed letter to the Truro Synagogue, which has often been cited as the basis for the concept of religious pluralism, a definition that is more inclusive and perhaps more appropriate to today's United States than the venerable term tolerance. Washington said, "It is now no more that toleration is spoken of as if it were the indulgence of one class of people that enjoyed the exercise of their inherent natural rights for happily. The government of the United States, which gives to bigotry no sanction, to persecution no assistance, requires only that they who live under its protection should demean themselves as good citizens in giving it on all occasions their effectual support." Our speakers today have dedicated their careers to considering issues of the appropriate interaction between religious liberty and our U.S. laws. Greg Lipper and Kristina Arriaga as counsel on key cases in the U.S. Supreme Court and in the states. Michael Gerson as one of the nation's most thoughtful public intellectuals writing about the intersection of religious belief and politics. Greg Lipper is with the Americans United for Separation of Church and State, and before that worked at the Covington and Burling law firm. Kristina Arriaga is with the Becket Fund and has been the counsel in Hobby Lobby against Burwell and a number of other cases, and tells me that she has quite an eclectic collection of pets at home, and we learned that in the green room. Michael Gerson is a columnist with the Washington Post. and also works with the One Foundation on alleviation of disease and poverty globally. There are two categories of cases that we're going to talk about today. The first are the more traditional types of cases in the religion field, the accommodation cases, and they often involve minority religion and the place of accommodation of minority religion in a majority society. There's another category of cases which are very much in the news, which is what I would call religious accommodation 2.0. Those include cases like the Hobby Lobby against Burwell case and the cases that are now growing out of the state RFRAs. I know that since that's in the news, that's very much on everybody's mind, and since we have the counsel on both sides of the case with us here today, we'll ask them to start off by telling us about what has happened in this area since Hobby Lobby against Burwell. And I'll start off with Kristina Arriaga.
So you may wonder why my hair is a little messy. Greg and I already got at it in the green room. And I've been specifically asked to talk about areas of agreement. I'm working hard on it. As I'm sure you hear my accent. No, I have not been drinking. I'm Cuban American, so I feel very passionate about these issues. I'm, as Meryl mentioned, the executive director of the Becket Fund for Religious Liberty. So one area of disagreement that we have is the Hobby Lobby case. So as you may have heard, Americans United mischaracterized it as crazy evangelicals denying health care to women. That wasn't actually the case. I'm kidding, Greg, I know. You never said crazy.
She's paraphrasing.
So the Green family of Hobby Lobby are a evangelical family from Oklahoma City. They started their business in a garage with a $600 loan. They started to make mini frames. They pay their kids 7 cents each for making the frames. And as the devout Christians, they closed, when they opened their stores, and they eventually opened stores in 46 states. They employ 26,000 employees. They close on Sundays. Their trucks only take merchandise into the stores. They don't allow the trucks to bring alcohol. They have no loot cards in their stores. And they provide this very generous benefit, healthcare benefit to their employees. They pay for every medication, every drug, everything that the Affordable Care Act required. But when the Health and Human Services mandate was enacted, they had absolutely no objection to 16 out of the 20 drugs that the government mandated. They only objected to 4. And these 4 drugs were drugs that the government itself conceded may prevent implantation. That was the science behind this was never argued in the case. The government said it prevented implantation. And for the Green family, that was a form of early abortion. They could not cover these 4 drugs. So they covered 16, they covered everything else. They had great health benefits. And because of their values, they also paid more than twice the minimum wage to each of their employees. And they found themselves painted into a corner by the government. The government, while forcing the owners of Hobby Lobby to provide these 20 drugs, exempted millions of Americans from having to comply with this mandate that they consider so vital. The case became incredibly politicized. You may have heard about it. And indeed, when the government went before the Supreme Court decided their case was very weak because they lacked their arguments were not strong enough, and we won that case. And in that case, the government said that closely held corporations have a right to religious liberty. Since there was a big hysteria then that rights would end, healthcare would end, women would die, none of that has happened. It was all very politicized again. And since then, any court decision that has come down has largely benefited very individuals in prison or individuals who want to exercise their right to religious liberty. Does that answer your question?
Well, I think that Greg probably has a slightly different version of the facts here. So.
The facts and the legal principles. Before I start, Meryl mentioned Thomas Jefferson. It's actually his birthday today, so it's a very appropriate day for us to be having this discussion, and I'm sure he's proud wherever he is. But so I want to. It's a big question. Michael has
We're not going to ask you to resolve that here today.
So let me take a step back, actually, before we get into this particular weeds of the Hobby Lobby case, because the Hobby Lobby, although it's often portrayed in the press as a case brought under the First Amendment, it was actually brought under a statute, the Religious Freedom Restoration Act. And that was enacted in 1993 in one of the great political kumbaya moments where people on the left, people on the right, all came together to support legislation co-sponsored by Ted Kennedy and Orrin Hatch. At the signing statement, President Clinton talked about the proverbial, divine intervention to bring all these people together. And the premise of the Religious Freedom Restoration Act was that there are some cases in which accommodation should be made for people's religious beliefs, for people's religious practices, so that even if the law on its face did not discriminate on the basis of religion, there were some cases where greater exemptions should be provided. And it's especially important to religious minorities. So, for instance, Muslims or Sikhs who need to wear a beard, notwithstanding a particular dress code or facial hair policy, or to the extent there are requirements of autopsies when that violates someone's religious beliefs. What has happened, though, in cases like Hobby Lobby and in places like Indiana and Arkansas, is kind of the Religious Freedom Restoration Act has now been weaponized as a tool for some people to impose their religious beliefs on others and to deprive third parties of their rights. And I think that was something that has not been allowed to happen before, that there are many situations in which accommodations are appropriate, but they have never been, until this Hobby Lobby case, allowed when it would deprive someone else of their rights. Now, what's happened here in Hobby Lobby and these other contraception cases is that for-profit commercial employers are permitted to withhold what is otherwise required healthcare compensation. Some of the employers refuse to cover any contraception, some refuse to cover much of it. In the case of Hobby Lobby, though, I take Kristina at her word that nobody has died as a result of it, but tens of thousands of Hobby Lobby's employees are deprived of certain forms of contraception, including the IUD, which most medical professionals agree is far and away the most effective form of birth control and is also the most expensive, and which virtually all modern scientists agree does not act as an abortifacient at all. And so, there had been cases previously in which people had raised religious objections to Social Security taxes, or to paying women the same as men, or to paying, the minimum wage. Those claims had always been rejected because, be it individuals or companies, have never been allowed to use the religious beliefs of their owners to harm third parties, including their employees. That consensus has now broken down in a deeply fractured Hobby Lobby decision, and it is going to have, I think, profound consequences for the way we understand religious liberty and for the balance in our country between the rights of religious worship on the one hand and a system of secular laws that protects everyone on the other.
I want to get back to this notion of weaponized because I think that there's an argument that can be made on both sides about weaponization. But I do want to ask you, Kristina, the case that said that RFRA did not apply to the states was a 1997 case, Berner against Flores. It's been 17, 18 years since the decision of that case, and we are only now starting to see a big focus on state-level RFRAs or mini RFRAs. There is a disturbing correlation between that and the passage, for example, in Indiana of gay marriage. So does that suggest that perhaps the focus on RFRA has something to do with factors other than those that are being articulated by the plaintiffs?
What was the last part of it?
The being articulated by the proponents of the RFRAs.
No, I mean, as soon as the 97 decision came down, several states started to adopt RFRAs. We have 21 states with Religious Freedom Restoration Act state versions of it. And over 30 states now have religious protections that were RFRA-like. So many states felt they did not need to have a RFRA protection in their state. Also, there was a sister legislation called RLUIPA. We're so nerdy, we're talking with all these acronyms, the Religious Land Use and Institutionalized Persons Act. And for a Cuban to say that quickly and without tripping, it's quite the feat. So So RLUIPA also protected, but to your point, Greg, of who benefits really from these Religious Freedom Restoration Act, one of our clients, Pastor Robert Soto, is a Native American in Texas. In 2006, the Department of Interior sent covert agents. Department of Interior had covert agents that went into his family powwow because they had heard that he had eagle feathers, and there's an Eagle Feather Act that prohibits Native Americans that are not in a federally recognized tribe to have these feathers. So they sent covert agents, confiscated his feathers, which were essential to his practice as a Native American pastor. And it is thanks to Texas Religious Freedom Restoration, the Federal Religious Freedom Restoration Act, that the government had to return these feathers recently. So it is true that the original RFRA was meant to protect minority religions, and most of our clients are minority religions. What RFRA never ever said or never alluded to was anything having to do with what we're going to discuss later, which was sexual orientation or gender identity. So I think that the states moved as quickly as they could, given the '97 decision.
Mike, I want to bring you into the conversation. So these RFRAs in the states, how do you see controversies over florists, cake baking? How does this play out, and what kinds of accommodations should be made, not just for minority religions, but for people who have lives that may not be ones that are as easily accommodated by evangelicals or people from certain religious beliefs?
Well, it's a little strange. I am a non-combatant in this legal battle, and given where I'm sitting, I'm just likely to be a casualty in this legal battle. You know, the history of RFRA seems to be relevant here. This was, a two-part test about compelling, governmental goals and the least intrusive means. That was a cause championed by Justice Brennan and the ACLU for many years, and was in effect for decades. And it was really Justice Scalia who was the bad guy in this scenario, who wrote the Smith decision that overturned this and caused the Congress to react and reinstate this test. Because, and it was in the House, it was Chuck Schumer that took leadership on this. It passed the Senate 97-3. And it really was a point of agreement. It is a shame, a terrible shame, when issues this important get sucked into the vortex of the culture war. Because what we're talking about is not just one issue among many. We're talking about one of the great achievements of the American tradition, which is the protection of a kind of religious pluralism that's actually good for the country. It's motivated over the years people to do good. Religion has when it comes to hospitals and homeless shelters and Catholic charities and a variety of religious groups, and it's motivated this search for justice over the years in the abolition movement, prison reform movement, and other things. Religion is not religious freedom is not some problem to be solved, some controversy to be engaged in. When you hear George Washington's statement from earlier, that is a thrilling moment in the history of the world, in which a power like America came to the defense of a genuine pluralism in which people could pursue their own visions of the good with respect for one another. So I hate to see when RFRA laws are used in ways that are suspect, because it actually, I think, brings discredit to that cause. But I would also say that RFRA standard, which we've had for decades, has really never come up against this public accommodation laws. That hasn't been a problem for decades. All that standard does is say that there should be a balancing test, not guaranteeing any outcome, but accommodating deeply held religious beliefs. So, I think that you can question people's motives in bringing up RFRA laws in the states, but this balancing test has actually been a well-tested, pretty good method to accommodate the normal rules of the majority and a handful of exceptions of people that feel like their beliefs are being burdened. And it's the courts that make this decision, and they've generally been wise in its application.
So let's talk about the Little Sisters of the Poor and Notre Dame case versus Hobby Lobby, right? So Little Sisters of the Poor and Notre Dame seem more traditional in the sense that these are religiously owned and religiously affiliated organizations that are refusing to provide particular categories of benefits. Mike, do you see a distinction between that and people like the Green and Hahn families?
I think that a lot of people engaged in this issue, there are some divide, even on the part of advocates of religious liberty, between those who put a great emphasis on the autonomy and identity of religious institutions and those who would extend it to for-profit institutions. I think that divides some of the coalition on these issues. It's the Indiana law, as I understand it, actually made sure that it applied to for-profit corporations, and I think people are maybe more mixed on that. But I guess I would defer to the experts on.
And I'm going to ask him.
Right.
Greg?
So the cases like Little Sisters of the Poor and Notre Dame and the sort of second wave of challenges to the contraception regulations, I think they present actually two important distinctions. The first is the one that you mentioned, Meryl, that these at least look closer to actual religious institutions than does a national retail craft chain, on the one hand. On the other hand, these entities have already received a significant accommodation and refused to take yes for an answer. Because for 2 years now, the administration has said, fine, you do not have to include contraception, any form of contraception, in your health plan. All you have to do is fill out a form saying, I object, send it to your insurance provider, and the insurance provider will then provide the contraception coverage to your employees at no cost to you, at no cost to them. That was still not good enough. All of these entities are challenging it. I refuse to fill out this, signing this piece of paperwork makes me complicit in evil. The administration granted even further accommodation, said, okay, you don't even have to fill out the form and send it to your insurance company. Just fill out a form to the government saying, I object. Send it to the government. And again, these entities have refused to take yes for an answer. The basis of what the Supreme Court ultimately said in Hobby Lobby is there's a less restrictive alternative because the government has created this accommodation for these nonprofits, but these nonprofits, many of which Kristina's organization represents, are arguing even that filling out the form so that somebody else will provide coverage to their employees is objectionable. Basically saying we will not rest until our employees are unable to get contraception from anyone. And I think that is, it's I think another example of the sort of extreme weaponization of religious liberty, but it also, I think, contributes to the things that Michael has talked about, that when religious liberty gets associated with, denying women vital health care, denying women control over their bodies, and refusing to sign paperwork, that is deeply troubling to the cause of religious liberty as a whole. And you saw the same thing in Indiana and Arkansas. When religious liberty is associated with discrimination, with denying people service at public accommodations, that is deeply troubling. Religious freedom restoration acts have become toxic, and they've become toxic because they've been abused in these ways. When Governor Pence is saying, no, this isn't about discrimination, it's actually about when his fallback is, no, it's actually about depriving people of contraception. That is deeply troubling. It has eroded what had been a great consensus in favor of religious liberty, and I think it's going to do long-term damage to the broader cause.
Kristina, do your clients not take yes for an answer?
Those Little Sisters of the Poor, so unreasonable. They devote their lives to serving the elderly poor. They take care of 13,000 elderly poor people. They hold their hands while they're ill. They help them die. And they're committed to life at the beginning, in the middle, and at the end. And they just said, hell no, we won't go. I mean, they didn't say the word hell. Mother Lorraine would be really upset if she heard me say that. The government has exempted millions of Americans from having to comply from this mandate for commercial reasons, for secular reasons, because they were the government's friends, because they felt like it. But they refused to exempt this order of nuns. And then they created this paper game. Sign a paper, sign here, sign there. It's a money game. You guys are all a lot of you into money things. I'm mathematically impaired. But it doesn't take a lawyer, and it doesn't take a mathematician to understand that someone has to pay for it. And when the sisters sign that piece of paper, it triggers a contract. Someone else has to pay for it, and they consider that to be an illicit thing. They consider that to be a sin, and the government is not in the business of telling people what they can and cannot believe, or whether they believe what they believe is reasonable, unless they have a really important reason to tell them. We have 3 teenagers. Who has teenagers? I think it's completely reasonable to advocate for churches that consider human sacrifice of teenagers, right? You would agree with me, right? No, well, the government has the right to come in and say it's in the compelling interest of the state not to allow human sacrifice. For those reasons, the government can come in and intervene, but the answer is not government intervention. As to the for-profit, it doesn't take a lawyer to understand that a gay musician or a gay photographer should not be forced by the government or anyone else to go and photograph an event at the Westboro Baptist Church. And this last week, both the ACLU and Americans United both said that indeed the gay photographer should be forced to participate in an event at Westboro Baptist Church. No one in America has ever supported those claims. You know, Freda Levy, whom we all know and love, who advocates for the legalization of marijuana. My children are watching, I never inhaled. So, why should she be forced, if she were an artist, to participate in a no drugs rally? That it doesn't, people disagree about religion and sex all the time in America. And the answer is not to bring in government regulation, and the answer is not to exaggerate claims. Has it been weaponized? Absolutely. There has been intent on both sides that has not been good. But that does not mean that you wipe an entire body of law that calls for a day in court simply because someone's view you consider to be repulsive.
Well, what about this notion that you're simply, the government is going to take over providing the contraception if the Green and Hahn family don't provide it? I mean, how is that different than the case of the conscientious objector? Because the conscientious objector, if they don't give their service, somebody else will have to give their service. And certainly you would say conscientious objectors statutes are fine.
No, it's very different. When the Little Sisters of the Poor say, we cannot pay for it, that's very different from someone taking it. They just cannot pay for it. The government already provides millions and millions of dollars in funding through Title X to Planned Parenthood clinics that provides these drugs to women that want them simply by showing up for free at no cost to the woman. This is all taxpayer money. I mean, the government figured out a way to put a 50-cent stamp on a piece of paper and carry it from Florida to California. Is it 50 cents? Maybe it's 51 now. To get a letter from California to Florida. Why can't they figure out a way to get these contraceptives to women that does not involve nuns? They put a man in the moon, but they're forcing the Little Sisters of the Poor to violate their conscience and have to pay for these drugs and devices that they object to. That's unprecedented.
I think, though, Kristina is losing sight of the idea of balance, that it isn't for us to question necessarily the reasonableness of a nun's unwillingness or anyone's unwillingness to fill out a form saying someone else go do it, but we are dealing, we don't live in a theocracy. We balance interests. There are other people at stake. There are employees who will go without coverage if the nuns won't fill out the form, or if anyone won't, or if the University of Notre Dame won't fill out the form. And to say, well, the government could pay for it, the government could pay for anything, but we wouldn't say, for instance, that I have a sincerely held religious objection to paying women the same as men. we would never say, well, the government has money, they can make up the salary difference, so no big deal, right? No, we would say we are going to enforce equal pay laws. We wouldn't say, I have a religious objection to paying minimum wage. No big deal, the government can make up the salary difference. We would reject that form of claim, let alone saying, I refuse to fill out a form. I think Meryl's question about the conscientious objector was absolutely right. Notre Dame's lawyer was asked at the oral argument, does that mean that it would be a substantial burden on religious exercise for a conscientious objector simply to say, I object? And he said, yes, that even that would have to be considered a substantial burden. And again, that's all well and good for people to believe that is fine, but when someone else is losing an important benefit as a result, that's when I think there has to be balance brought. And I think that the idea that I am entitled to every possible idiosyncrasy, in my beliefs is fine, but when, as a result of those idiosyncrasies, other people lose their benefits, that's when it crosses the line in what ultimately is a society based on secular law.
Okay, we're gonna leave it there. Clearly not something we're going to be able to resolve, but let's try to find some areas where both sides may agree a little bit more, and that may get us back to some of the more traditional areas of the protection of minority religions in a majority society. And the most recent example that I think that I've looked at out of the court is the Holt against Hobbs case, and I think maybe that's an area where more or less you both agree.
Yes, we do agree. We actually, Kristina's organization represented a Muslim prisoner who wanted to wear a half-inch beard in prison. The case was brought under that Religious Land Use and Institutionalized Persons Act. Kristina and I actually disagree on how to pronounce the acronym, because she says Arlupa and I say Arluipa, so even then we have disagreement. But that was a case in which that was the sort of situation that brought the coalition together, right? A modest religious accommodation that's important to someone's religious beliefs, and granting the accommodation doesn't harm anyone. There was arguments made about threat to security, but they didn't really hold up. And I think that is a case where we do agree, where religious accommodations laws are serving their intended purpose. You know, I think it would have been very different if it was, I have a religious right to not associate with women prison guards. I think that would then cross over into imposing religious belief on someone else. And there we might disagree. But in sort of the quintessential accommodation, doesn't hurt anyone, no reason not to grant it. Yes, I think there is plenty of room for agreement about those cases.
So, one of the reasons that the Supreme Court ruled that this prisoner had the right to grow the beard, it was because the state of Arkansas had no real reason, right? There are no security reasons. The state of Arkansas had said, you cannot grow the beard, you have to shave just because we said so, just because we said so. And that was the weakness of the argument. And in the case of many of the religious freedom cases we were seeing, the ones where we're defending our clients is because oftentimes the government says, hey, you have to do this just because we said so, like Little Sisters of the Poor, like Hobby Lobby, like many of the cases where the government had no real reason to not make an accommodation and not make an exemption. But yes, in the end, we do agree that this was an important case. Now, the Barry Lynn who started, did he start Americans United? No, he
started in 1947.
Oh, well, he'd be very upset.
I won't tell him you said that.
No, you look good, Barry. You don't look that old. So the Barry Lynn, for instance, belongs to the Universal Church of Christ, and 14 pastors in the state of North Carolina from the same denomination, supported by Americans United, are suing the state of North Carolina because in the state of North Carolina, same-sex marriage is not legal. What these pastors want, along with Barry Lynn, is their day in court. And that is what the Religious Freedom Restoration Act does. They give a day in court when there's disagreement.
Let's try to get off of referendum and try to talk
Oh,
about...
I thought we wanted to talk about
No, we want to talk about some other things as well. And actually, I'm going to turn it over to Mike at this point. Are these cases, the religious accommodation cases, are they becoming more difficult? Are we becoming, as we become increasingly pluralistic, Is that creating a pluralism anxiety, as Professor Kenji Yoshino called it in his article? And are we getting to a situation now where these religious accommodation cases may become really difficult for the courts to deal with?
I do think that there's more at stake here than just disagreement on details. There is a conflict of vision behind many of these cases. There is a form of modern liberalism that essentially says that only the individual and the state are real in any meaningful sense, and that one of the main roles of the state is to protect individuals against oppression by other social institutions. And then there is an approach that I would call a kind of principled pluralism that says that a community of communities that allow people to seek a vision of the good consistent with the common good is actually a positive thing. It has a positive value. So I do think it really matters what perspective, what political philosophic perspective you bring to a lot of these issues. I come from a more conservative and Burkean side that says, in fact, the most important institutions are not the state, and more than the individual. They're the institutions in which the individual is shaped, where morality is passed, where culture the standards of a culture are created, and that the government has a positive role to nurture that pluralism, that kind of principled pluralism. So I do think that there are some deep political philosophic disagreements behind this that aren't just going to be solved by appealing to the details of cases.
So how do we deal with pluralism in an increasingly diverse society?
Very carefully. I think at the end of the day, I think there needs to be humility and there needs to be empathy. And those are, the word empathy is sort of derided in some circles when lawyers say it, but I think it's important. And I think it's important on both sides. We are a diverse society. We have people with diverse views, and we can't always get everything we want. And sometimes we should get what we want, and sometimes we shouldn't. And I think what has disturbed, me and many of my colleagues about the weaponization of Religious Freedom Restoration Act is sort of.
He said RFRA.
I did say RFRA. It's true. And that we pronounce the same way. But the idea that, for instance, my rights are different when my ability to act 100% in accordance with my religious beliefs is different when I'm at church than when I'm at a business. When I'm at church, if I want to pray with only people of the same race and religion and sexual orientation, I can do that. But if I open a lunch counter, or if I am a caterer, even if I devoutly believe interracial marriage is wrong, I still can't turn away that couple. And so I think it's really, at the end of the day, I think we need to recognize that there are other people out there too, and that religious beliefs are extremely important and extremely deeply held and extremely devout. But in a country based on secular law, they can't be a trump card. And that can be a very painful thing, but I think it's an important limiting principle that is necessary to balance everyone's rights.
Can I add one point? I agree strongly that a democracy is designed for disagreement, but it's undermined by mutual contempt. That actually emphasis on civility, empathy is an important part of this discussion. So I was just in Salt Lake City, Utah, talking with some church officials. And they really did attempt a process by which church officials met with gay rights activists and legislators in a difficult negotiation to come up with an approach, the Utah law, which is an exchange of sorts. It specifically protects gay people for public accommodations, which I think was regarded by that side as real progress, and specifically protects the ability of religious institutions to maintain their identity in positive ways. Jonathan Rauch, who I know, was involved in that effort and hopes that it may be a model for some other states. It could be, but it is shows the possibility of civil disagreement and at least minimal agreement on some very basic ground rules of pluralism.
When we're talking about civility, let's also talk about what was at one time considered to be the repository of civility, and that is the college campus. And there's a lot going on right now in terms of religious liberty and free exercise on college campuses. Is the approach being taken on the campuses of providing access to everybody to religiously affiliated organizations the right approach? Is there enough respect for civil discourse on the campuses now, or could the campuses do better?
Well, Greg Lukianoff, of course, is the expert on this issue. But I think it's closely associated to the points that you have made having to do with civility and having to do with empathy and having to do with accommodation. When my parents first came to the United States, we lived in a tiny, teeny house, and which in Puerto Rico, where my mother had been in a concentration camp in Germany, my father was Cuban. They had, let's just say, some bad experiences leaving Fidel Castro's Cuba. And whenever we sat down for dinner, my father would close the one window in the kitchen. This is Puerto Rico, 1960s. I was very young. And it was very, very, very hot in the house. And he would say, just in case. And he was so afraid that our discussions would be overheard by our neighbor. And as he understood that this is not the way we live in the United States, and we opened that window, we drank from the fountain of freedom of expression. You know, we could not disagree enough and yell it loudly enough. We could not drink enough from that. And the reality is this: for as much civility as we want, for as much agreement as we want, for as much empathy as we want, sexual minorities particularly, and religious minorities have mutually reinforceable claims against larger society. And there's some issues associated with human identity that are so important and so vital, no government should touch it. No regulation should touch it. And so much for civility. When it comes to matters of human identity, the government should protect them, not invade them. Religious liberty is the ability to live according to our deeply held convictions, live according to our conscience, and whether that takes you to organized religion or no religion at all, there's no room for government intrusion into that life. And the same thing should apply at colleges and universities. Now it's become the trend that if your group doesn't agree with larger society for whatever reason, then it should not be allowed on campus. And that is wrong. It tears at the fabric of American society and of freedom when groups are not allowed on campus, when someone's view is held so repulsive that is not allowed in society.
Greg?
So let me take a step back and I think I heard I think there's a lot of what Kristina said, but I want to actually start with the college campus and then tie it up to a broader point. I think the specific issue that Kristina was alluding to is that many colleges will recognize student groups, which gives you access to certain resources and whatnot, you know, the school's messaging system, et cetera, et cetera. And in order to take advantage of that, you have to have basically a non-discrimination policy. And there's been an objection by certain religious groups, either involving exclusion of people of other religions or exclusion of gays and lesbians. Case went up to the Supreme Court. The Supreme Court held that even a public university can enforce its non-discrimination policy on student groups. Even in those cases, student groups can use university facilities. They just lose certain benefits. And I think what Kristina says is, look, if it's a student religious group, they should be able to exclude people. And I think what I guess where she and I kind of disagree, both on this issue and the broader point, is that we don't live in a 100% libertarian society, that we balance, individual liberty with other interests in things like equality and non-discrimination, and that especially in the unique environment of an educational institution, it is reasonable for a university to say, look, if you want to have a university-recognized student group, we're going to require you not to discriminate. It doesn't mean that you can't worship however you want in your dorm room or wherever else. It's simply be, if you want to take advantage of university facilities, it's reasonable to say you have a non-discrimination policy. I think this touches, though, on a broader point, which is we have never had this, your religious beliefs say you can do whatever you want no matter what. I mean, the Civil Rights Act, it reduces individual liberty. You can't turn away African Americans from your barbecue place. There was a case that went up to the Supreme Court called Piggy Park, which, in addition to being delightful to say, involved a restaurant owner who said, I have a sincerely held religious belief that prevents me from serving African Americans, and I want a religious exemption from the Civil Rights Act. And the Supreme Court laughed him out of court. And so I think at the end of the day, what steps back is, yes, we need to create space. Even the Piggy Park guy, if he wants to worship at a segregated church, can do so. But I think we have to sort of recognize that we are dealing with diversity, we are balancing interests. What is appropriate for certain settings, like your own home or your church, is not necessarily appropriate for other settings, like the commercial sphere. And I think we really have to do our best to reconcile a lot of different interests and not allow any one of them to be a total trump card.
I would only add that there can be a human cost to this kind of controversy. A few years ago, some human trafficking programs that were located at the Catholic bishops were denied funding by the Obama administration because of other policies they held, religiously based policies they held. I think that was a real cost. You look at a case like Gordon College in Massachusetts that has worked for years with a local lower-income school district and devoted 14,000 man-hours of volunteer work every year, where the school district has made a decision because of Gordon's religious views on other topics that they're discontinuing that contact. It's children who suffer in a circumstance like this. So I think there can be, particularly when it comes to the provision of social services, many of which come through private and religious institutions in America in that partnership, a too rigorous application of some of these points can have a kind of serious human cost.
I think the vegetarian group should be able to say that the leader has to be vegetarian. I think the women's feminist group should demand that its leadership be women feminists. And I think that a Christian group or a Muslim group or a Hindu group should say the leaders of anyone can come. By the way, none of our clients have said that they discriminate against anyone. Anyone can join the club. They want their leadership to abide by the mission of their club. I mean, what are we supposed to make everything vanilla? And as a Latina, I particularly love when race comes into this issue. The racial card does not need to get played on any of these. Yes, are there despicable people that have claimed a religious reason to have certain views? Yes, but those cases have not won. And in fact, in the last 22 years, as has been said repeatedly, there hasn't been one single exemption to an anti-discrimination clause based on a RFRA claim or a religious claim. That case was settled in the Supreme Court with the Bob Jones decision. So will people say crazy things in the name of religion? Yes, that's why they go to court. But you use that extreme example and justify government intrusion into all these groups. It doesn't make sense.
But I think what's happening is that the precise argument that was made to justify racial segregation and racial exclusion in the 60s and 70s is now being made when it comes to gays and lesbians. And I think that's why the parallel. I'm not saying Kristina's a racist or her organization's a racist or any of that. What I'm saying is that look, why can't I run my business according to my religious beliefs and I don't want to participate in certain types of ceremonies? Those are precisely the arguments that were made with respect to race and interracial marriage in the 60s and 70s. And so if they were rejected then, as they were and as they should have been, they should be rejected now when it comes to gay and lesbian couples who are now facing the same types of obstacles that racial minorities were in the 60s and 70s.
Name one case in the last 22 years when a gay person was refused service based on a religious claim.
Well, but the cases are in their early stages, but your organization is in court arguing that they should win. And if you actually want to look at what happened in Indiana, there was a case in New Mexico in which a photographer refused to photograph a same-sex wedding ceremony. She brought a claim under the state's Religious Freedom Restoration Act. The court rejected the claim. The court actually said, and Kristina's organization filed a friend of the court brief saying that the photographer under the state RFRA should be able to deny service to the gay and lesbian couple. The New Mexico Supreme Court said, no, this statute can't be invoked by a private wedding vendor. And so in Indiana, the language was changed to allow that protection. I think it's fine to, if your organization wants to support those people, great. But to then turn around and say, no, it's not about discrimination while you're arguing in court they should have a right to discriminate. I mean, it's like withhold, you want to be able to withhold your cake and eat it too. Which is it?
Let's talk about those people.
Well,
Elaine,
we're
just
running
one
out of
second.
time. We're
Just
running out of time.
Just Elaine, I just
Okay.
need to say, Elaine loved this gay client of hers and provided flowers for many, many months consistently. All she could not do was participate in the wedding ceremony. And in the state where same-sex marriage wasn't even legal at the time, the court ruled that it was the price of citizenship for her. I mean, who lost more? Who lost more? Elaine, who lost her business and her livelihood, or the gay couple who could have gone to any other florist in the state?
And this is all I would say is that you're entitled to the view, but you can't then turn around and say these laws aren't going to allow discrimination because you were in court saying
It's very
this
different
law,
to serve than to have to
Well,
participate
but-
in a ceremony.
All right, so we're going to give Mike the last word, and I'm going to give Eugene Volokh the almost last word. He wrote about whether there are mutual duties of accommodation, and so we've heard very strong articulation of two different positions. So, Mike, just because you have a right, should you exercise it, or are there mutual duties of accommodation that we need to be thinking about in order to guarantee the cloth of society as we go forward?
I think it's quite possible that religious belief and ethical conscience would dictate baking the cake. In a society where you would allow some very small exceptions for people not to bake the cake. That is the nature of pluralism. And it does not implicate the broad accommodation for housing and businesses and other things. But be that as it may, I guess what we're talking about is where those decisions are made and whether there's a decision to be made at all. The traditional view has been that there is a balancing test here. There's actually two rights involved. And the courts have been the place where those decisions were made. And so it's all that said, it's very important that people win graciously in a democracy and lose graciously in a democracy. And people are going to lose in these cases. And how people lose will make a large difference.
And with that, I want to thank our speakers and thank the National Constitution Center for hosting us today.